So welcome to this webinar on NEC contracts for infrastructure projects. I'll come on to how we're going to go through this today. We've only got an hour, so we'll do our best to give you a bit of background to NEC and some of the issues that come with it. So hopefully you've got a slide that has Rachel Reeves and what's her name again? Taylor Swift, just to demonstrate my knowledge of that. Now, Taylor Swift is up there because We Don't Talk Now, I believe, is a song that you may or may not have performed. Perhaps the more important one is Rachel Reeves, who has said quite helpfully at the start of the week that we're going to build thousands of houses. What do houses come with? Houses come with infrastructure projects. And what we're finding is that infrastructure projects tend to be using NEC. And we've seen a steady increase in the use of NEC. It's been gradual. It's not been sort of overnight, and it's been over the last sort of 10 years. But what we see as construction specialists is more disputes on NEC, more people asking us to review contracts on NEC, and more issues effectively that arise with NEC. And despite, certainly with some members of the public sector kicking and screaming, wanting to stay with JCT, people are moving over to NEC, not least because the public sector is positively discouraged from using anything else other than NEC. In practice, I'm just putting my glasses on so I can read my notes. In practice, NEC is best used for infrastructure projects. JCT is probably best used for building works, but NEC theoretically can be used for all. NEC is produced by the Institution of Civil Engineers, which is, again, by its very name suggests it should be a civil engineering type work. We are also seeing Section 278, Section 38 agreements now being carried out pursuant to NEC forms of contract. And one of the reasons for why now and why this talk, well, local authorities and house builders are going to be encouraged. And one assumes that, you know, the moment you ask for planning, you'll be given it immediately to build houses. We find that some local authorities, some house builders are pretty weak on their knowledge of NEC. We find some of their advisors are pretty weak on their knowledge. And we also find, to a certain extent, some of their lawyers are pretty weak on their knowledge. This is not to say by any means that all lawyers and all advisors don't understand NEC, but it's definitely one of those areas where knowledge is key. We're not going to tell you everything in an hour, but we'll do our best to give you a flavour for what is different with NEC compared to some others. We're going to do it in three parts. A basic overview, why is NEC so different to maybe contracts you're used to? And then we're going to look at some examples of the type of questions that people ask or want to know the answer to, as a way of explaining the differences between NEC and perhaps your more standard forms of construction contract or more other forms of construction contract. I'm just briefly going to mention, for those who don't know anything about Archor, this is actually a bit of an out-of-date slide. We have three more people other than on here, but this is the team. All we do is construction work. We don't profess to be any good at anything else. So we are working for all parts of the construction chain, through from local authorities, developers, house builders, contractors, you name it, we'll work for them. A lot of that stuff is dispute work, and unfortunately a lot of that dispute work is now NEC based. Before I pass you over to Hayley, you can just see over here, Hayley is a senior associate at Archor, and just over here, Sarah is a legal director. Between us, we'll be doing the talk. Hayley will do the next sort of 15, 20 minutes, just giving you a basic overview of NEC. So if you don't understand it, don't know how it works, hopefully by the end of this next 20 minutes, you will. Over to you, Hayley.
Thank you, Andrew. Just move the laptop.
Oh, don't keep me in the picture.
Can do. So the first point to make is that all contracts, whether it be JCT, NEC, ICME, or any other form of construction contract, is that it's simply there to define what happens when, and in a global sense, apportion risk between the parties. The key for all parties is understanding how those risks are apportioned, what this means for each party, and whether the parties actually recognise that they have accepted such risks. The issue with NEC contracts is that the baseline apportionment of the risks is very different to that in a JCT. One example would be an unforeseen or force majeure event, such as COVID-19. Now, under JCT, the contractor would be entitled to an extension of time, but no money, whereas under NEC, the contractor gets time and money, and we'll come on to how these operate in greater detail later. Another example would be ground conditions. Now, ground conditions are obviously vital for infrastructure projects. And under an NEC, any unforeseen ground conditions would mean that the contractor is entitled to a compensation event, whereas under JCT, these are deemed a contractor risk standard. The examples above highlight that it is naive for employers and contractors alike to turn around and say that we should use the unamended standard forms of contract, especially as there may be requirements from third parties, or the risk profile needs to be amended to reflect the bargaining position of the parties. The key here is understanding those changes, which again we'll come on to in greater detail shortly. So firstly, what are NEC contracts? Now, NEC contracts are not JCT. You may ask why this is necessary to go over whilst it's already pretty clear. The issue here is that people continually operate NEC contracts as if they were JCT contracts, and that simply does not work. In very simple terms, a JCT is a retrospective contract and an NEC is prospective. NEC is all about dealing with any issues straight away, whereas JCT is more focused on dealing with the matters at the end. An NEC contract is drafted on the basis that it will be operated in a particular way and does not have clauses that say, if you don't operate the contract the way we expect you to and do it a different way instead, then it works like this. So the contract becomes incredibly difficult to operate unless the parties understand the guiding principles behind this and act proactively. Retrospectively managing an NEC contract does not work. Now we move on to the NEC suite. Now, NEC is designed to be used for any type of work and for all types and sizes of project. And it has a number of different types, from term contracts, short form contracts, to the main contract and subcontract suite. As mentioned previously, it's probably best suited to infrastructure and/or civil engineering works. And unlike other contracts, NEC has lots of separate parts that can be adopted depending on what particular requirements that you're after for your project. We'll come on to these different parts shortly, but in theory, you stick all the relevant bits together and off you go. Now, NEC is currently available in both the NEC 3 and NEC 4 forms of contract, which are essentially two separate editions. The fourth edition is not significantly different from NEC 3, and there's no reason why NEC 3 cannot be used. Now, NEC, like JCT standard contracts, have subcontracts that go along with the various main contracts. As a main contractor, this is great as it allows you, particularly if you're not familiar with NEC, to start with a decent form of subcontract as a base. That being said, it's not just contractors that will be careful on the subcontract forms, as employers often require collateral warranties from subcontractors, and therefore it will want to ensure that a sensible subcontract is in place to protect its interests. Now, what are NEC contracts? Now we've gone into a little background about the editions available and the forms of contract. What exactly is the ethos? Now, NEC was born out of the report from Sir Michael Latham called Constructing the Team in the early 90s, where he concluded that the construction industry was a mess with far too many disputes and a lack of cash flowing between the parties. One outcome of his review was to create a new contract, the NEC, which was referred to as the ECC at the time. The stated intention of the ECC was to move away from the old-fashioned adversarial forms of contract and establish a new collaborative model on modern principles of project management. One key element of this is that the contract is drafted in the present tense and places obligations on both parties to collaborate and solve issues as they arise. This form of contract is meant to be used as a management tool, i.e. use it throughout the job to help the parties get the job done, rather than a backup document to point fingers in the event of a dispute arising. Whilst the employer's agent or contract administrator under JCT, it's important, the project manager under an NEC who carries out a similar role as the contract administrator is absolutely vital under NEC, as they are much more than simply an administrator or agent acting on behalf of the client. Under NEC, a project manager's job is to facilitate collaborative working, cultivate team spirit, and drive the NEC approach. manage the project proactively, not just act as a postbox, and ensure that the parties cooperate and give proper notices as required, but at the same time, not allow the project to drown in bureaucracy and paperwork. The PM must have a high level of authority to act on behalf of the client and take rapid decisions affecting the rights and obligations of the parties to the contract. And the PM will have a lot of key roles, including dealing with early warning notices, or EWNs, compensation events, or CEs, and certifying completion, etc. The NEC is also famous for having the first clause to state that parties shall act in the spirit of mutual trust and cooperation. Although the obligation of trust is quite weak in English law, the courts are both willing and bound to take notice of the existence of these provisions. The case of Burson St David's in 1999 illustrated that where parties have signed elements such as a partnering charter, in addition to standard forms of contract, the contract must be interpreted in light of the obligations of trust and cooperation, so that the employer cannot insist on strict compliance with notice periods. Andrew, in fact, had a client years ago where a large water authority form of NEC had removed the mutual trust clause, which was not the best start. Now we've covered the ethos, let's start about how NEC contracts are formed. Now, each contract where an NEC is used is set up on the same basis, and they all use the same base documents. The first issue is to choose a core option, which come in options A to F. The choice of core options under NEC works similar to the levels of design under JCT, but under NEC, the focus is on how that job is valued. For NEC, the primary core options of A to F are based on whether the contract is fixed price, target cost, or cost plus fee. After the core options, there are a series of secondary options known as the W, X, Y, and Z options, which allow you to pick and mix the bits that you want to include on top of the pricing. So, for example, if you wanted to include retention, you'd use the relevant secondary option X16, and if you wanted to include liquidated damages or delay damages, you would use secondary option X7. So let's start with the core options. With options A and B, both of these are fixed pricing mechanisms. Option A is the most common as this is based on an activity schedule, whereas option B involves the use of a bill of quantities. And the clients typically do not want to take the risk of the work being remeasured. In simple terms, the only basis upon which a fixed price can change for option A is via a compensation event, and there is no such thing as loss and expense, variations, or extensions of time under NEC, as these are all dealt with under one claim, this being a compensation event, which we'll come on to later. One way to know if your advisors are familiar with NEC is often some will talk about loss and expense, changes and/or variation. These are all JCT concepts and not NEC. It's important to note as well with options A and B that if a secondary option X1 is used, that would be the only other circumstance which would give rise to an adjustment to the contract sum. Naturally, after A and B comes the core options C and D. Now, both of these options are target price, where a target is set, and if the contractor completes the job for less than that target, there is a sharing of the gain. But if the job comes in at more than that target cost, there is a sharing of the pain. It's essentially open book contracts subject to a cap. The difference between the C and D options, again, is that C does not have a bill of quantities. So if the target price approaches to be used, C is almost always used for the same reasons stated previously. If you think about it, for any compensation event, the target price must change. So if a client wants to instruct an additional building, this would be a compensation event, and the target has to move by the value of this compensation event. As with option A and B, the target only ever moves as a result of a compensation event and for no other reason. Following C and D comes E. So this is effectively a cost plus basis and is very rarely used. There is also an F option. This is a management contract form, but we've never seen this used at all. So if you have seen it, just let us know. Following on from the beginning of the alphabet, we then move on to the secondary options under NEC, and rather oddly, these move to the end of the alphabet being W, X, Y, and Z clauses. So what are they? Your first options are your W options, And in almost all cases, W2 will apply unless the Construction Act doesn't apply to this scheme or the matter is overseas. We won't spend much time on this other than to state that W2 is important, as this creates a contractual right for the parties to adjudicate without having to rely on the scheme. But adjudication will always apply under any contract regardless of the option selected. It's just whether this is contractual or scheme. Moving on from W, there are now the X clauses, and we've broken these down into 3 categories for you. Now, as described earlier, X options are add-ons that you can choose for your contract and have particular purposes. The ones on the slide here are commonly used and adopted when drafting and include elements such as sectional completion, delay damages, termination by the client, and retention. Secondly, we move on to X options that are occasionally used but less frequent than those previously. So for public sector contracts, they tend to include the use of KPIs, but there's a word of warning here, as KPIs will only ever work if there's a sanction that goes against it. Other optional clauses include an ultimate holding guarantee, information modelling, performance bonds, and early contractor involvement, which is similar to a PCSA. Finally, there are X options that are almost never used, which include a right to price increases for price inflation, bonus on early completion, low performance damages, and whole life cost. After X clauses comes the Y. So these are known as YUK1, YUK2, and YUK3. Option YUK1 relates to a project bank account, and YUK2 is the Construction Act clauses, which are incredibly important as they incorporate the due date, final date for payment, payment notice date, payless notice date, and a right to suspend for non-payment. Option YUK3 is also increasingly used as this incorporates the Contracts Rights of Third Parties Act. Following Y comes Z. So unlike most contracts, NEC also recognises that the parties may want to further amend the contract. Some parties may choose to do this via what's known as the Z clauses, and some parties may choose to amend existing clauses, but they essentially are the same. Parties have to recognise that NEC, like all contracts, is a base document and will need to be amended in some way to reflect the relevant scheme, financial position, and nature of the site. So Z clauses typically cover elements such as an obligation to provide collateral warranties or any local authority specific amendments such as bribery, modern slavery, data protection, or anything else that's relevant to the particular scheme or client. So now that we've covered the core and secondary options overall, let's see how they look in a contract. So on the slide here, you'll see an example of an NEC contract. And from this, we can see that the contract confirms that it's a fixed price contract based on an activity schedule with a contractual right to adjudicate. Alongside this, there is an ultimate holding guarantee to be provided by the contractor, a requirement for sectional completion and delay damages to be payable by the contractor, alongside undertakings to be provided. This requires the contractor to use information modelling, a retention to be held, and the contractor has a limitation on its liability. This also incorporates the Contract Rights of Third Parties Act and has a set of Z clause appended. Now that we're comfortable with the background of NEC and the basic concepts, I'll now pass you across to Sarah, who will go through a little bit more about NEC and what makes it different.
Thanks, Hayley. Just smoothly passing the top across. Good morning, everybody. Okay, so as Hayley mentioned, we are just going to spend a little bit of time looking at why the NEC is so different from the JCT, for example. So before we delve into the specifics, just as a brief recap between the NEC and the JCT, we just wanted to highlight some of the key differences between the two suites as a bit of a summary. So firstly, the choice of NEC contract isn't based on the extent of liability that the contractor has for designing the works. So under the JCT form of contract, the form of contract used is based on how much responsibility the contractor has for design. NEC doesn't deal with design in that way at all. In fact, NEC deals with design in the same way throughout all of their suites of contract. The choice of contract is based purely on how the contract is to be priced. So those are the options A to F, I think, that Hayley mentioned earlier. Under the NEC contract, the programme is a very key document. It has specific and actually very important contractual effects. We're going to talk about those in great detail in a minute. Under JCT, this isn't the case. The JCT contracts often include a programme, but it's not a contractual document as it is under the NEC. Another key point, and Hayley has mentioned this, is that the NEC contract doesn't use extensions of time and it doesn't talk about loss and expense. All delay and all monetary claims are dealt with as compensation events, and each compensation event, potentially at least, entitles the contractor to both time and money. This isn't dealt with the same way under JCT. Delay and loss and expense claims are separate. And as I'm sure you all know, not all delay events will automatically give rise to an entitlement to loss and expense as they would do under the NEC contract. The other really key difference is the terminology of the contract and the way that the contract is actually written. So there are lots of examples of different definitions, different wording used. And a key one is the NEC contract calls collateral warranties undertakings. We don't really know why. Collateral warranties are used throughout the industry under every other contract, but that's how they do it. I think Hayley mentioned delayed damages, which is how the NEC refers to liquidated damages. So there are various different definitions that kind of need to be learned. But another really key difference is the actual tense that the contract is written in. So the NEC contract uses present tense. So it's probably easiest to explain this by way of the example on the slide. Clause 20.1 in the NEC contract says that the contractor provides the works in accordance with the works information. The JCT, if it was drafted in a JCT style, would say that the contractor shall provide the works in accordance with the works information. The obligation is exactly the same, but this does often lead to some confusion in how the clauses should be interpreted, with the kind of the lack of the word shall is often seen as a lesser obligation. It's not in reality. This issue has actually been acknowledged by the courts as causing confusion. On the slide is a quote from Aikenhead's judgment in Atkins Limited and Secretary of State for Transport, where he acknowledges that actually the way that it's written is quite confusing for the parties. So that is just something to bear in mind when looking at the contract. So there are two key points that we wanted to spend a bit more time on because they are very important differences between JCT and NEC. There are other forms of contract, but these are the two key ones. So apologies for the constant referral to JCT. So we want to spend some time talking about programme and compensation events. So firstly, looking at the programme under the NEC contract. So as we've already mentioned, the programme is a very key feature under the NEC contract. The contract programme is referred to as the accepted programme. It's also sometimes known as a clause 32 programme. A key example of how much importance is placed on the programme is that the employer is actually entitled to withhold up to a quarter of any payment due until the contractor has provided the required programme. So it is given significant importance and a direct financial penalty if the contractor doesn't comply. So unlike JCT, everything under NEC is measured against the accepted programme. There are very detailed requirements for what information has to be included within the programme. And as we've said, it is a very key document. And this very clearly isn't the case under JCT. It's probably not a huge surprise to hear that the accepted programme is key when assessing delay. If a compensation event is instructed, the effect on the completion date is measured against the then current accepted programme. and the effect of that delay is assessed against the then planned completion date in the current accepted programme. So in practice, it's all very straightforward. You simply look at the planned programme, add the effect of the compensation event, and if it changes the completion date, the contractor is entitled to a change to the completion date. That all sounds very straightforward. We all know in reality that's not quite the case. The issue with how NEC deals with delay analysis and using the programme is that it actually ignores what is physically going on site, because everything is taken back to the accepted programme. So you can already see that if the accepted programme isn't up to date, this causes all sorts of issues. So it is a straightforward process, but it doesn't necessarily take into account the real world position. However, if, and this is quite a big if, the contract is operated correctly, it does provide certainty. And as Hayley has suggested, and as we'll come on to see, the NEC is all about certainty. That is the purpose of the contract. JCT works on the basis that the parties typically wait until the end of the job. They work out what effect the delay actually had on the works and on the completion day, and then they work back from there. So JCT takes a fully retrospective view. So in theory, the NEC contract gives you greater certainty, and arguably the JCT contract gives you the true position, although we say arguably because, as we all know, this is not always the case. So moving on now to compensation events. As Hayley's mentioned already, a compensation event is the only basis on which the fixed price or the target price can change under the NEC contract. The first point is that, and this has already been mentioned, but a compensation event deals with both time and money. So whilst the contractor is not necessarily entitled to additional time and money, because the effect of the compensation event may not be to change the time and money provisions, there is at least an entitlement to both for every compensation event. So unlike JCT, it isn't a separate claim process. There's no split between a delay claim and a loss and expense claim. They're all dealt with together. So any compensation event, so an obvious example is instruction change to the works information, will need to include the effect on the date for completion and the effect on the prices, so any change to the prices. We'll come on to how you measure the change to the prices in a moment. And by prices, we mean in JCT terms, the contract sum. So we don't have a great deal of time today to talk about compensation events. It is a very detailed part of the NEC contract, but we're not going to be able to go into a huge amount of detail here. So this is really more of an overview of how it works. It's worth noting that there is a concept in NEC of early warning notices. Most of the contracts don't include early warning notices. Basically, this encourages both parties to give notice of risks and how those risks could have an impact on the time and the cost of the project. Whilst it's encouraged, if a party fails to give an early warning notice, it doesn't actually affect their right to a compensation event. It does potentially have an impact on how the compensation event is assessed. So early warning notices are important, and certainly from the contractor's perspective, it's important to get them issued, but it doesn't prohibit a compensation event being claimed. The first key point related to a compensation event is that the contractor must give notice of a CE within a given time period, and the standard period in the NEC main contract at least is 8 weeks. If the contractor fails to do this, they lose their entitlement to the compensation event. So the 8-week notice requirement is a clear condition precedent. This is very important. The time period is often amended. We're going to talk about amendments a bit later, but it's usually reduced to at least 4 weeks, most contracts that we see. So before a compensation event can even be considered, the first question is, has the contractor notified the event in time? There are no equivalent provisions in the JCT contract, at least in its unamended form. This is something that is usually amended to make the entitlement to additional time subject to a strict notice provision, but the standard JCT doesn't deal with it this way. So I apologise, Andrew put the slides together. He likes some pictures, but good old Judge Judy there. So basically, if the contractor doesn't notice a compensation event, they lose their right to additional time. So what can be a compensation event? Well, really the list is exactly what you'd expect. There are some differences between JCT relevant events and compensation events, but largely they are similar. The key ones we've put on the slide. This isn't the entire list, but these are the main ones. So unsurprisingly, if there's a change to the scope or the works information, depending on whether you're using NEC 3 or 4, this will amount to a compensation event, much as a change to the ERs would under a JCT. The employer restricting access or an employer impediment will obviously give rise to a compensation event. Interestingly, and this is different to JCT, the NEC contract allows the contractor to claim compensation event for unexpected ground conditions. Hayley mentioned earlier that this isn't the same in the JCT contract, which assumes that ground conditions are a contractor risk, which is also the common law position. So that's certainly something to bear in mind. Adverse weather is dealt with. This is dealt with in a far more prescribed way than under JCT, but in effect, the contractor is entitled to additional time and money in the event of adverse weather. There is also a restricted form of force majeure clause, which is called prevention under the NEC contract. The parameters for being able to claim a prevention clause are relatively strict under NEC. And as I've already said, and we'll keep on banging this point home, the effect of the event is measured both in cost terms and time terms. So they all give potential entitlement to both. So another important thing to note in relation to CEs in the unamended NEC is that the project manager has an obligation to respond within a specific timescale. So Hayley mentioned the importance of the project manager's role under NEC, and this is one example of that. So the contract works, but the contractor would issue and would notify a compensation event. Along with that, they would provide their assessment of the value of that compensation event and the time impact of that compensation event. This is simplifying what is actually a very detailed process in the contract, but this is essentially what happens. So as an example, the contractor assesses a compensation event at £1 million. The project manager then has a week to reply to this. They can either agree it, or they can ask for a revised quotation, or they can reject it. The contract sets out the specific reasons that entitles the PM to either request a revised quotation or reject it. If the project manager fails to do this within the week that they're allowed, the contractor then has the right to inform the project manager of this failure. The project manager then has a further 2 weeks to respond. If they don't, I mean, you would hope that if we're talking about £1 million change, that the project manager would be on their toes and be responding, but you would be surprised. Timescales slip. If they don't respond, or if they forget to respond within that additional 2 weeks, the contractor's quotation is deemed accepted. And that is accepted irrespective of whether the value of the change should have been £1 million or £1,000. It doesn't matter if it's correct or not. So there is an obligation on the project manager to act. The whole contract is based on this idea of proactive project management. it certainly isn't a form of contract that you can write up and then forget about until the end of the job. It just doesn't work like that. It's all about certainty. And so there are a number of provisions, particularly around the programming and around the compensation event clauses, which mean that if the parties don't act in the way that the contract tells them to, certain matters are deemed approved. So it is very important that the contract is followed. So how is a compensation event valued? This is another very key point. It is one of the areas where parties who are used to working under a JCT form of contract often get things wrong, and this does often lead to dispute. So under a JCT contract, the contract says that a change or variation is valued based on the same rates and prices as are set out in the contract. So it uses the contract sum, rates and prices. The NEC contract is completely different. It does not use rates and prices in the contract at all. Any compensation event is valued on the actual cost to the contractor. So the NEC guidance, there is some very useful guidance linked to the NEC contract, and it states that the contractor shouldn't be penalised by the issue of a compensation event. So effectively, if the rate in the contract was always too low, the contractor doesn't continually get penalised for the same rate if something then changes. So just to reinforce this point, the rates and values in the contract aren't relevant when assessing a compensation event. The actual cost payable comes into force when a compensation event is instructed. An NEC contract provides that the contractor has to give a quotation for its forecast actual cost. So again, it's looking into the future and what things will happen. If that is accepted, then that's it. It's final. As I said, there are opportunities for the project manager to challenge this, provided they do it in accordance with the contract. So the contractor doesn't recover his actual cost, but the forecast cost. So if the compensation event turns out to cost the contractor less, then the contractor benefits. If it turns out to cost more, then the employer benefits. There are detailed provisions in what is known as the schedule of cost components, or the shorter schedule of cost components, depending on which pricing option is used. And this sets out which costs are to be counted when making this assessment of forecast cost. It includes all sorts of things. It includes things like bonus payments, overtime, pensions, travel. It's a very detailed schedule. We're going to come on in a little while and to explain in more detail by way of an example as to the effect of this and the way that compensation events are priced. So that brings us on to the final section of the presentation. I'm just going to move this back so you can see all of our lovely faces.
And we're going to come on to that immediately. So the way we're going to do this, Hayley's got to do less of the work, is that Hayley's going to ask us the questions. Me and Sarah are going to have this rather sort of question time style, backwards and forwards.
So we very like question time.
Be whichever political party candidate you think is appropriate for my personality, and Sarah can be.
Got blue and a green.
I'm not sure I might actually be in reform colours, so it's not necessarily the right thing to do. Anyway, I may have made that a bit clear. Right, so if we go to...
So question one.
Question one.
So when would you use option A or option C? Shall I jump in?
Yeah, you jump.
Okay, so option A is your sort of traditional lump sum fixed price contract. So as Hayley mentioned earlier, option A is very popular. If you've got an NEC, it's 8 times out of 10 going to be an option A contract. It's generally used for sort of the straightforward jobs. It's used where the parties want cost certainty. You might argue that that's always the case, but you know there are projects that are suited better to other pricing mechanisms. So yes, anything straightforward. It's also probably advisable if parties aren't used to an NEC contract because it's easier to operate. So that's option A. An option C contract essentially gives a capped price and it's got an incentive built in for the contractor to come in at a lower price. So basically, the parties are continually incentivized to find cost savings throughout the life cycle of the project.
Yeah, so option A is fixed. Option C is target cost. So the contractor actually gets paid his cost, which is cost likely to be somewhere near the target cost. But if he can find savings, if you can get an alternative contractor, if you can come up with different approaches, then his cost will be reduced. It will be less than the target, and all of a sudden there's an amount of money saved, if you want. And then the parties do is then share that in whatever proportion they've agreed to share it. Mm-hmm. Typically, that might be sort of 50-50. So typically they share the gain 50-50, and typically they share the pain 100-0, where the contractor takes all the pain,
yes.
The client doesn't. And our experience is that option C is used for more complex jobs. And if you think about an option C job, the person certifying each valuation has got to go through the costs. Whereas on a fixed price, which is not a cost-based job, they're just looking at the percentage of work done. So it's much more administratively heavy to use an option C. But for big jobs with parties who know what they're doing, it's an opportunity to work together and save money. And the best example of where we see it quite a lot is on network rail type jobs. They're almost always let as option C. Ironically, then the subcontracts are often let on option A. So the main contractor's got an option C and the subcontractors have got an option A. So there's no given reason why you can't use either, but you would understand that if it's an experienced client, if it's a complex job, you may actually go for an option C. One thing is quite complicated of option C is how you assess the target price in the first place. But assuming you come up with that, then they're the two options. I would also say, even though it's not on the slide, option E, which is just simply cost plus, is occasionally used where a job is urgent, super urgent. So, for example, or where a contractor's gone past and another contractor needs to finish it. So, option E is it's not atypical to see. You can see option E. What you don't ever see is option F.
Option E is not usually the first sort of.
It's not.
Not the first on everybody's mind. It's normally something that's done.
So that's the question. That's the first question.
So moving on to question 2. So are compensation events really priced on actual cost?
Well, the simple answer is yes. As we mentioned earlier, it is actual cost. You don't use the rates and prices. Well, you shouldn't. I should say you shouldn't use the rates and prices under NEC. That's not to say that doesn't happen. It quite often does, as we're going to talk about in a minute. I think probably this is easiest explained by way of an example. So I've got an example up on the screen. So that's looking at where some works are omitted. So I think actually it's easier to explain it by way of an omission, but the principle works the same the other way around. So in the example, an element of the works which had an original value of 500 grand in the contract is omitted from the contract. So there's an instruction to remove that piece of work. The contractor prices the omission under the NEC contract at 200 grand. And that's because the contractors managed to do a deal, which means that the cost, the actual cost of the removal of the contaminated soil, which is our example, would have actually only cost him 200 grand rather than his originally projected 500 grand. So if he was going to do the works, that's what it would cost him. So he would obviously have had the benefit of the 300 grand. So the value of the omission under a JCT contract, your contract administrator would quite rightly argue that would be valued at 500 grand and the contract sum would be reduced by 500 grand. Under NEC, that is not right. And the contractor would be quite right in arguing that the actual cost to them was 200 grand for the omission. Well, that's what it would have cost them if they had carried out the work. So under the NEC contract, the correct value for the omitted work would be £200,000. And that is this is very simplistic, but it's quite difficult, I think, for lots of practitioners to kind of get your head around because it is very different to JCT. And it can benefit either party. Yes, that's how it's managed.
Yeah, so firstly, Sarah sounds like a gangster because she keeps talking about grand and not thousand.
Oh, sorry, 10,000.
So clearly she's
I
got...
used to work at a contractor, that's why.
But this example is actually one, I've kept it sort of anonymous or whatever, but this example is actually one I had, and the numbers aren't identical, but they're not dissimilar. And I think the real problem was the employer thought by removing the contaminated material from the contract, they were going to get a saving of $500,000. And the problem was that isn't what they got back. Their project manager wasn't as au fait with NEC as as some others. And actually the contractor was correct. It's the cost to the contractor. And another way to look at it is the contractor was going to make £300,000 profit on that work because it's only going to cost him £200,000 and it had a £500,000 price in the contract. As Sarah mentioned earlier, the contractor should never be worse off as a result of a compensation event. That's a sort of ethos behind NEC. So the contractor retains the profit. So it retains the 300. And I think if the particular client had known this, they probably wouldn't have bothered omitting the contaminated material. But that is one of the sort of issues with NEC. I'm just going to talk you through another case, which is all about how you value compensation events. So we've just we don't have time to go through everything, but the way NEC compensation event should work is everyone follows the contract, everyone gives the notice, gives a quotation, accepts the quotation, whatever varies the quotation, and it's all great because it's all done entirely the way the contract says it should be done. The truth is that isn't what happens, and we all know that isn't what happens. What actually happens is what's said on that slide. I need to get my glasses and just read it. The work commences at some point. Someone says, "Oh, this is a compensation event." Someone's told to carry on and finish it. We'll sort it out at the end. They get to the end. They haven't agreed a price. So where was the notice? Where was the instruction? Where's the quotation? And none of it's done. And this is unfortunately all too common. And it comes back to the same point. The contract expects you to follow the contract and manage it as you go along. But we all know this is what happens, and it happens a lot. Now, there is a case on this called Northern Ireland Housing Executive and Healthy Buildings. I have to be honest, our view, and I think quite a lot of people's views, it's probably wrong, but it does highlight what can happen where you are, I'm going to have to increase the size of this so I can't read it, where you don't follow the contract. So in this case, it was an NEC professional services contract, but it's still an NEC contract, same principle. And Healthy Buildings were carrying out asbestos work in Belfast for the Northern Ireland Housing Executive. And they were instructed to do various additional works. But no one provided a quotation. No one really did anything, quite frankly. And then 4 months later, there's a notice given, and all of a sudden, the housing executive decide they're not paying for it. So you've got this situation where work's been done, has the right notice been given, and how do you assess this? Because all the work's been done by the time anyone starts to look at what should be the price. Now, as we've already discussed, you should have a compensation event. It should be based on forecast actual cost. Well, the job's already been finished. So how do you forecast an actual cost when you've got an actual cost? Now, the real answer is, I think, that the courts should have said, well, we need to work out what we thought the forecast actual cost should have been. That isn't necessarily what the court decided. So it went to adjudication, and Healthy Buildings won, so that they were claiming that their cost should be based on their very belated forecast. The adjudicator agreed with them. After going initially to the High Court, it then ended up in the Court of Appeal. So the Court of Appeal has got to decide the situation of, do you sort of guess what someone would have given a forecast cost at the right time, or do you use the actual cost that you know by the time this comes to be decided? And so these are the two questions, does the NEC contract allow you to look at the actual costs? Yeah, well, I suppose they're both the same question, to be honest. And the Court of Appeal said it is slightly ridiculous to come up with a guessed forecast cost when you've actually got the actual cost. Now, that is not the way the contract works. And of course, you can see what can go on here where parties don't give these numbers. Then all of a sudden they get to the end and they go, oh, well, you know, it's not what I forecast, it's what I actually incurred. Now, that's not the way the contract's meant to work. The contract's meant to work is that the parties agree a forecast cost, or if it's halfway between the, you know, if the compensation occurs halfway through doing it, there's a bit of actual, a bit of forecast. Because this encourages parties to not comply with the contract and then just get paid actual cost.
Yeah. And
there was a sort of rather famous statement, you know, which can be taken in a number of ways depending on your sense of humour. But the judge, one of the court appeal judges says, why should I shut my eyes and grope around in the dark when the material is available? So they've effectively come up with a position where, well, if you haven't bothered doing anything properly, you use the actual cost. Mm. And of course, this has created a huge amount of confusion now, because when you have a dispute, everyone relies on this case saying, well, we didn't do it properly, but actually we're entitled to our actual cost. So again, it's another very clear reason why you need to follow the contract. And this is completely different to the way JCT would work. You know, actual cost, forecast cost is irrelevant. You'd use the values, you know, or you come up with a fair and reasonable price. But the problem is people keep operating the contract like a JCT.
Yeah.
And then you end up in this scenario. So that's what trying to get across is the key difference.
Yes, as Hayley said earlier, the NEC really doesn't work when it's operated as a JCT contract. It's got to be operated in the here and now, because the contract doesn't really deal with what happens if you haven't. So yeah, it is quite important to keep on top of the contract.
Question 3.
So thank you guys for a great response to question 2. So question 3 is, so how do you measure delay to the completion date under NEC?
So this is another part of the contract where it's really important to follow the contract and do things as and when they occur. So the contract has very clear obligations as to how and when the accepted programme is to first be submitted and then be updated by the parties throughout the contract. And delay to the completion date is always measured against the then current accepted programme. So you can see that if the current accepted programme is the programme that was drawn up right at the beginning of the contract, and either the contractor hasn't then regularly submitted updated programmes, or those updated programmes have been submitted but haven't been accepted by the project manager, and if the contract has been amended in such a way that the deemed accepted provisions have been removed, which is very often the case, you're left in this real muddle where you're trying to assess the effect of a delay against a completely out of date accepted programme. And as you can quite imagine, this is another area where there is a lot of dispute, because you're then trying to work out what should the delay be based on? You know, how should the assessment be carried out when the accepted programme is quite obviously completely out of date, and that is clearly going to heavily favour one or the other parties.
Typically what we find is that contractors do submit programmes.
Yeah.
But typically, for whatever reason, sometimes because the employer or the project manager doesn't like what it says, it doesn't get accepted.
Yeah.
So you've got this bizarre situation, as Sarah says, where you've got lots of programs that have been submitted but aren't classically defined as accepted. And then you get a dispute about a delay, and you're using a program that's 6 months out of date. And the problem for the employer is, if I'm an adjudicator, I've got sympathy with the contractor, haven't I? Because I've put in a program and they haven't bothered looking at it or haven't bothered approving it. So as a contractor, I can almost choose which one suits me the best. So again, you know, it's and there are really good. I should just make the point, and you know, some of them are on the call on the webinar. There are some really good project managers who understand NEC, but you know, if you've got project managers who don't, or are, you know, or think they're being clever by not approving programs, the irony is it's probably the other way around. It benefits the contractor. And we do see this quite a lot where, you're then, the contractor's got the benefit of choosing which one gives him the best change to the completion date. And it's very difficult for the employer to argue against that because the employer was the person who refused to accept it in the first place. So two really different concepts all keep coming back to program and compensation events, and it's just a different mindset. And if you don't have the right mindset, you will end up spending more money on an NEC than if you get it right in the first place. You'll be pleased to know we've only got one question there.
So question 4 is, so what amendments should the employer be thinking of making to an NEC contract?
And that's good side. So
you do often hear it said, or sometimes hear it said that mainly by the people that drafted the NEC, that the NEC doesn't need to be amended. Well, that isn't really true. All standard form contracts really are a sort of starting point, and they need to be adjusted to reflect the actual project. And there are certainly some provisions in the NEC that, certainly from an employer's perspective, that you probably would want to amend. There's a few examples up on the slide. There are probably lots more, but these are the sort of key ones.
I'm just going to say a good example is force majeure.
Yes.
Force majeure event is a what you could often call it a neutral event, but it's an event that neither party has any control of. So neither party could foresee COVID-19.
Yeah.
But on an NEC, the contractor gets time and money. Well, that doesn't seem quite right. So you might, for example, for certain events which are neutral events, you see lots of provisions where people say, even though it's an NEC contract, for this compensation event, you are only entitled to time or not. So, it's not, typically the person who takes the risk is the person who's in the best position to manage it.
Yeah.
Or no one's in a position to manage COVID-19 when it occurred. So it just seems a bit odd that contractors got paid money for that. Whereas under a JCT contract on exactly the same site, on exactly the same works, they wouldn't get paid money. So there are a whole host of things that probably need to be amended. And then you've also got to consider what the site is and who's taking the risk and who's got the money. And I know any infrastructure projects are not quite the same as buildings. So most building projects have a funder behind them who's going to dictate exactly what's put in it. Civil engineering projects aren't often the same, but there are often third parties involved who, so it's not always the lawyer driving this, it's often the money driving the change.
Yeah.
Just right at the bottom, whilst there are some really good project managers who understand NEC, you probably want to take out the things that say if they don't do their job properly, everything's deemed accepted, because, and that is a very common change.
Yeah.
But strictly, you shouldn't need that because they should be doing their job properly. Anything else?
I think most of them are sort of the obvious things, really.
But and we've said it a couple of times. We do get this. Why are you amending the contract? Well, there's a whole host of reasons contracts are amended, and it's not just because people want to make it more difficult for the contractor. That is often the case, by the way, but because people want as close to a fixed price as you're going to get. And the contractor has to accept that, and the contractor will value that risk, and that's what comes with contracting. But it's just not. It's too naive to say that a base contract that's been designed to be used on every job, everywhere, is suitable for your particular job.
Yeah.
And actually, not having fully rehearsed this, it's lasted 59 minutes, which I,
There you go.
take some credit for that, if nothing else. So. Thank you all for listening. If you're still there, this is available. Bizarrely, it goes on YouTube because Ollie sorts out and we end up on YouTube. If you've got any, there are some questions in the chat, so we'll have a look at those and see any response to that. And so if you've got any questions after this, then let us know. But with no further ado, we'll say goodbye. And someone will press this button.